What you want to know. What you need to know.
Talk 1470. WNN.
The opinions expressed on the following sponsored program are strictly those of the host, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors. Welcome to the South Florida Family Law Show with attorney Sean Shepard. Sit back today as attorney Shepard shares his vast family law experience. Attorney Shepard has 18 years in the area of family law. He has handled thousands of cases and hundreds of contested trials before both judge and jury. He is here every week to educate you on your rights and to answer your questions pertaining to family law. If you have a question regarding family law, call attorney Sean Shepard toll free at 888-565-1470. And now, here's attorney Sean Shepard.
Good afternoon. Another week in the books. It's 5 o'clock Friday. Welcome to your drive home. If you're already home, welcome home. We're here to talk about family law. I'm Sean Shepard. I've been an attorney for 18 years now. I practice primarily in the area of family law and civil litigation. I'm here to answer your questions. If you should have any, feel free to call into the show. We encourage calls. If you have a question, you can call in anonymously, of course. You can call in, provide a name if you'd like. You can also follow the show online on wwnnradio.com. There's a video of the show as well. You can call in at 888-565-1470. Give us a call if you have a question. Perhaps you're listening to the show today about family law and you don't have a question, but you have a family member or friend going through a family law issue right now. Give them a call. Tell them to tune into the show. We provide some helpful information to those people going through the process now. Whether you have an attorney or don't have an attorney, whether you filed for divorce or paternity or going to file for divorce or paternity, we're here to answer your questions on the show. Give a call in. We're going to talk today about several different issues. Last week we talked in depth about dividing up and equitably distributing assets and debts of a marriage. And in continuing on with different issues that come up in the area of divorce and in the area of paternity to some extent. One issue that seems to come up more often than not these days is proof of income, particularly in cases of divorce where you have family-owned businesses or small businesses or cash businesses primarily. The issue of proof of income is one that comes up and is a hotly contested issue in most cases. Of course, proof of income is something that's required in divorce cases, in any case involving either the establishment of child support or the establishment of alimony. And income, as you may remember from the last weeks that we've had the show, income is important because alimony, the two top factors a judge looks at in determining whether to award alimony in a case, is one party's financial need for the alimony and the other party's financial ability to pay it. So those two issues being the top issues in any determination of alimony, proof of income is on the top two issues of requirements at trial, to be able to demonstrate that the other party has the ability to support you with alimony. Proof of income also comes into play when trying to establish child support, because you have to demonstrate to the court that the party you're seeking payments from, whether they be alimony or child support, is making X amount of dollars in order to calculate an alimony or child support amount. I consider proof of income to be one of the, if there's a fun area of the law to practice in, proof of income in these cases is typically the area where it gets interesting. A lot of times you'll have a situation, I've had people come into my office and say, my husband or my wife runs this business, and there's a lot of cash that comes through the business. There's a lot of money that comes through the business, but I don't know how in the world I'm going to prove what he or she makes. And it's oftentimes difficult. Whenever you have a small business or a closely held corporation, it's oftentimes difficult to show where the money's coming in, where the money's going out, and proving income of that party in order to establish an alimony case. It's particularly made more difficult when you have one party that's being deceitful to the other or hiding money or those types of things. So Oftentimes people come into my office and they're discouraged at the proposition that they have to prove what their spouse makes, or that the mother and father have to prove what the other makes in order to get a child support award or an alimony award. And in all candor, when you go to court, you have to prove that to the judge. It's not simply walking into court and saying, well, I think my spouse makes this much money, or I think they may make that much money. You have to actually prove what the other party makes in order to have what's called competent substantial evidence of income, and that's what's required. So if you think you're going to walk into court and provide your opinion testimony as to what you think your spouse makes, and you think that's going to win the day, you're sadly mistaken. What you do in preparation for a trial and proving income of your spouse, or in the case of paternity, of the mother or father of the child, you have to go through the process of discovery and obtaining information that shows exactly what income that party's making. And in order to do that, it's oftentimes not simple to do. You have to go and go through the process of discovery. You have to obtain, remember we talked about financial affidavits being exchanged by the parties in all these actions. That's simply a starting point. Oftentimes, unfortunately, parties lie on those affidavits, or not necessarily lie, they may fudge what the numbers are. One thing you have to do is start with a financial affidavit, but don't rely that that's the truth. You do investigation, request for discovery, and discovery are all the supporting documents to a financial affidavit, the nuts and bolts of where those numbers come from. And those are going to include the bank statements from the business, bank statements from the individual, tax returns from the business, tax returns from the individual, and all other documents related to financial matters involving the business or the individual. So what we do is we start with the discovery process. We gather as much documents as possible from the other party involved. And oftentimes you have a situation where the other party says, well, I don't have copies of my bank statements, or I shred those monthly, I don't have them. You don't need to sweat about that. You can send out what are called third-party subpoenas to banks and other financial institutions in order to obtain those documents, even if your spouse doesn't have those. It does cost more to do it that way, but you're not at the end of the road if your spouse simply says, I don't have the documents. You do have subpoena power when you do have a case pending. For those of you represented by attorneys, subpoena power is in the hands of your attorney. Your attorney has the right to sign a subpoena on your behalf, provide notice to the other party that this subpoena is being sent out, and after 10 days to wait for an objection, has a right to send that subpoena to the third party and obtain records. So you want to go through the process of obtaining the financial affidavit from the other party, any third-party subpoenas for records, such as bank statements, tax returns, and other financial records in order to prove up your case. And you ultimately want to gather as much information as possible before you walk in and take a deposition of the other party. A deposition, for those of you who don't know what that is simply an opportunity for one party to ask another party, and if you have an attorney, for your attorney to ask the other party questions under oath as if they were testifying in a court of law. And you can ask anything that is relevant to the case regarding financial matters. It gives a good opportunity to see what the other side's going to say when they go to court. It gives the attorney or you a good opportunity to, if the other party's going to lie, to have a transcript of the deposition to use that against the other party at trial to prove that the other party lied. And it gives a good opportunity for you to do discovery in your case and find out the facts as they're going to come out before the judge if you go to trial. Oftentimes, as I said, with closely held corporations or small businesses, proving what the other side makes is oftentimes very difficult. And oftentimes you have cash payments that come in that don't make their way to the bank. So looking at bank statements in order to determine what one party's income is typically is not fruitful. And what I encourage people to do, and what I do in my own practice, when you have a business, a closely held business or a closely held corporation, small business, is don't focus so much on the income that comes in and trying to prove the income, because that's only one way of proving what somebody makes. What I will focus on, if I find that there's a lot of cash coming into a small business and not a lot of records being provided by a party, is I focus on the money that's going out. And you look at things that were purchased during the year. You add up the monthly expenses as indicated on the financial affidavit. You add up the monthly expenses as they're told you during a deposition. You factor in cash purchases for large items. And you come up with how much money that party or that business has spent over the year. Because as we all know, in order to spend money, you have to have money or make money. And I found that technique to be very successful in proving what somebody makes, because oftentimes, like I said, you can't have proof that somebody makes money, but you can find proof that they're actually spending money. And judges understand this concept. They understand that when you come into court and you show somebody who puts on their financial affidavit that they're making $3,000 a month and they have expenses of $6,000 a month and they're running a deficit of $3,000 a month, but they're not going into debt, that obviously that money is coming from somewhere, and instead of making only $3,000 a month, they're most likely making the $6,000 a month in income and just not reporting it accurately on their financial affidavit. I want to interject. I have a few questions that have come in. The first question is, if payments on child support are not made to receipt, what are the consequences of that person? So, and I think the question has to do, if you make payments of child support to another party, and whether it be in a paternity case or a divorce case, and there is no receipt provided for that, what are the consequences of that? Unfortunately, and I find this happens a lot, there's people who very informally deal with child support issues. They may give up another party cash from time to time. They may not receive receipts for what they pay from time to time, or they were ordered to pay money through a depository, and instead of paying it through the depository, for whatever reason, they decide to give a check directly to the other party, or to give cash directly to the other party. First of all, if there's an order in place that requires you to pay child support through a depository, and you don't make the payments through the depository, you are throwing money out the window. If you're ordered to pay payments through a depository, regardless of the circumstances, regardless of the demands being made on you by the other party, make the payments through the depository, because you're wasting your money if you hand cash or a check, even if you get a receipt for it. If you get a judge that is not happy that you've violated the order and not paid through the depository, it's very likely that you're not going to receive credit for those payments that you've made. And this is so even if both parties agree to it, if you get a receipt from the other party. So you're always best served following the court order and paying the money through the depository. And more often these days, there's a requirement that the payments of child support go through the depository, and most orders these days have that provision in it. And you should follow the court order and pay all child support through the depository. Benefits of the depository for child support purposes are obvious. You have a record with the state as to what you've paid, when you've paid it, and what your running balance is if you have an arrearage amount. In the past, payments have gone from party to party, and for obvious reasons, when there's either cash exchanged or money orders or things like that, it gets messy as far as the accounting of what's due. So most judges prefer that payments of child support go through the depository so that there's a record of those things. That's obviously a benefit, having that record there. The downside is that obviously there's a delay in the processing of those payments, and there's a fee associated with making those payments through the depository, and that fee is paid by the party making the payment. So in addition to the child support amount that's been ordered to be paid by the party, they also have to pay a fee to the depository itself for processing the payment. And the payment obviously doesn't reach the other party immediately. There is some delay and lag time between the date the payment is tendered and the date it's actually received by the recipient. So it's a good question. There's another question that came in. It says, can the principal parent be charged if the other guardian can prove their conditions can the principal parent be changed if the other guardian can prove that conditions are better for the children? And this is a question that goes toward a modification. And yes, the answer is yes. The courts, whether it be a paternity action or a divorce action, courts always retain jurisdiction over the children and the parties to the action to change things such as time sharing, they call it now, instead of custody, child support, and all matters related to children. So if you feel like there's some substantial change in circumstance that warrants, if you're a visiting parent or a secondary parent from a time sharing perspective, and you feel the primary parent that there are certain circumstances that have changed that the child would be better off with you, you always have the ability to file what's called a supplemental petition for modification. But it is a high level of proof in order to obtain that relief, and it's not something that should be taken lightly. A lot of people confer with me about these issues, and oftentimes the issues are not of such a magnitude that it warrants a modification, such as a change in a primary parent over secondary parent. But oftentimes there are situations that are significant enough that warrant such a change. Things you want to look at are how the children or child are doing in school, how they're doing mentally, physically, from a health perspective, both mentally and physically, how they're doing emotionally, whether they're getting in trouble. These are things that oftentimes trigger concern on the part of all parents, whether they're going through divorce or not. But if your child is going through significant problems or a deteriorating condition from both an academic perspective or a physical, emotional, health perspective, they're getting into trouble, all parents should look into those issues and determine what the source of the problem is. If the problem is something that you can attribute to the other parent, much thought needs to be put in before you file a supplemental petition to confer with an attorney to see whether you have a basis to file a supplemental petition. A lot of people, for instance, think that, well, my child's grades have gone from A's and B's and they're C's and D's now, so I'm going to file a supplemental petition because obviously my ex-spouse is not doing a good enough job doing homework with the child. Typically, that's not enough of a situation to cause a change in custody of a child, primary care for a child. There has to be a demonstration of something more than that, something that the primary parent is doing or not doing that's causing that problem. And the problem in the eyes of the court has to be something that is a substantial change in circumstances, and also that the second part to the test of whether or not to grant relief on a supplemental petition is that you have to actually prove to the court that to keep the child in the current situation would be detrimental to the child. So not only do you have to prove the first part, that there's been a substantial change in circumstances, you also have to prove that it would be detrimental to the child to remain in the current situation. It's a very high standard to meet from an evidentiary perspective, and certainly conference with an attorney on the issue is well advised prior to spending money on filing a supplemental petition and pursuing a supplemental petition. Make sure that you have enough to go on to make an argument for a change of that kind before you go ahead and file and spend time and money and effort and cause aggravation to a situation. Take a lot of time to consider that before you do it. And for obvious reasons, that you should, as a human being, confer with the other parent, try to come up with some situation that is beneficial for everybody involved. If there's a solution that can be had without having to get the court involved, that's certainly preferred, because you're talking about your children here and not about some stranger. So I encourage all parties out there to do their best to try and work through issues. Having done this for 18 years, I understand that oftentimes is not something that's possible, particularly when you have a situation that's deteriorated from a relationship with your ex-spouse, or perhaps you don't even speak anymore. And unfortunately, that could be part of the problem and part of the detriment to the child or the children involved, is the fact that the parents cannot get along together, cannot speak to one another, and that has some detrimental effects on the children as well. So first step, try to resolve the matter informally with the other party. Try to make your child better without having to file the supplemental petition. If all else fails and you feel that a substantial change in circumstances has occurred, and that to allow the child to remain where the child is would be detrimental to the child, consult with an attorney, see if you have enough to move forward to file a supplemental petition. And you have a right to seek a supplemental petition for modification regarding the child in any case where you've had a divorce decree, whether there was a judgment after a contested trial, or whether it's a judgment that incorporates a mediated settlement agreement. So whether you've settled your case and you have a final judgment, or you have a final divorce decree after a trial, the court always has jurisdiction to make modifications on child support and child custody issues. So keep that in mind. Getting back to the issue of proof of income, we were talking about issues of trying to prove when you have a spouse who doesn't have a traditional job where they make a salary or an hourly wage and it's easy to calculate what their income is. A lot of times these days you have somebody who's involved either in a sales position, or they have a small business, closely held corporation, where they receive their income from that business, and it's oftentimes hard to prove what their income is. And we were talking about doing that and going through the process of doing that. And one of the best ways of going about doing that is proving what the party spends during a year. It seems simple enough to understand, but a lot of people get so caught up in trying to prove where the income is coming in and what the bank account statements say and what this deposit was or that deposit was. One of the best ways to prove what somebody makes is to prove what they're spending. What I typically look to are bank account statements, credit card statements, cash purchases for large purchases, vacations that were taken where cash was spent, and you total up, pick a particular year, and preferably the year before the action was filed, and look over the course of that year what that party spent during the year. And that money had to have come from somewhere. And if you're able to demonstrate to a judge, look, my spouse spent between their cell phone bill and their car payment and their car insurance, their electric bill, what they spend on food, all these things can be found in their financial affidavit. And a lot of times you'll have a situation where you're seeking alimony from your spouse, and your spouse files a financial affidavit and says, I'm making $3,000 a month, my expenses are $6,000 a month, I have a $3,000 a month deficit, there's no way that I can pay alimony. What they've done for you is they've shortened your effort by establishing for the court that they spend $6,000 a month. So you start with the premise that, hey, they're making $72,000 a year because the financial affidavit says they spend $6,000 a month. So take that in hand, and from there you can build on that and prove that they're actually making $72,000 a year. How do you do that? Well, one of the things you have to avoid as a pitfall here is you have to look at everything. You can't simply add up all the expenses and say, well, they're spending $72,000, so they must be making $72,000. That's not all the time true. Sometimes you'll have a situation where people spend beyond their means, and it's unfortunately more often than not that's what's happening. And the way that they do that is they do that through credit. So one of the things you need to look at when you're going about trying to prove income of a party through what they spend is looking at how much credit they have out there. Do they borrow money from family members? Do they borrow money from people? Do they get cash advances? Do they have credit cards? Do they run up balances on credit cards? So you really need to look at the credit card statements. And what you need to do is, like I said, pick a year. So if I was going through a divorce process representing somebody in the year 2014, I'd look at the whole year 2013 as a snapshot of this person's life in order to try to prove what they're making and what they're spending. So I'd look at the January 2013 credit card statements, and I'd look at December 31st, 2013 credit card statements. I'd figure out what their credit balances were at the beginning of the year, what they were at the end of the year, and if they've not incurred any additional debt, credit card debt, then you can successfully argue to a judge that if they spent $72,000 in 2013, they had to have made $72,000 in 2013 because they haven't gone into debt with creditors. And I cannot tell you how many times at a deposition or at a trial where I've gone through this process and it has been successful. It works. If you go through with somebody and you take them step by step through the process of how much they spend on a regular basis, and you add up over the course of the year how much they've spent, and you establish through questioning them that they haven't gone into debt, they fall right into the trap of admitting that they had to have made $72,000 in a particular year, by way of example. So it's effective, it works, but you have to prepare for this if you're going to trial. Your attorney has to prepare for this going into trial so that there are no holes in this argument. There's oftentimes a lot of pitfalls where you have a very smart party involved who's being questioned, and they look for every opportunity to find a hole in your argument. And oftentimes you have a situation where they fall back and you get to the pivotal question of, well, you haven't gone into debt during the year any more than you were at the beginning. You've spent $72,000 this year, so you must have made $72,000. Isn't that correct? And they may fall back on the argument, well, I borrowed money from a family member, or I borrowed money from a friend, or something of that kind. You have to make sure that those holes are all clogged up through questioning at a deposition before you get into court. Ask them the questions. Have you borrowed money from anybody in the last 3 years? Have you borrowed money from family members in the last 3 years? Get all those pieces of the puzzle put together before you get into a trial so that you're not surprised by anything. One of the key things that I find to be helpful in proving income, and it's something that is not used often enough, if you think about the situations in which a party is going to be most favorable to what they're making during a year, it's when they're applying to get credit. So what I do in my practice, if I'm trying to prove that somebody makes a certain amount of income, one of the first things I ask for is applications for credit, applications for car loans, those types of things. Those will be the most telling with regard to what somebody makes, because when they're trying to apply for credit, of course they're going to put down what they're actually making, and if they're going to fudge it all, they're going to fudge and say that they make more than what they're making. But those are perfect pieces of information that you can use at a trial. If there's a car loan application or a credit card application, you want to get those pieces of information before you go to trial, because those can be very helpful. They're typically in the handwriting of the person who made the application. They're signed, they're dated, and they say what the party has in the way of income, says what they have in the way of assets. There's a whole lot of gems on those documents that help you at trial in proving what the other party makes as far as income is concerned. So when you're doing your depositions of the other party before trial, when you're trying to obtain information to help prove what the other party makes in the way of income, do not overlook applications for credit, applications for car loans. If the other party says, well, and oftentimes this happens, that I made an application for a car loan, it was up at the Chevy dealer, but I didn't keep a copy of the application, by all means do a third-party subpoena and get a copy of the application they made, because it's going to be helpful in your case. Do not overlook it. Don't skip that part of the process. Make sure that you get that application. Same thing goes with credit cards. When you are making third-party requests for discovery and you ask for, you find out what the credit card numbers are of the other party and what they're using, a lot of attorneys and a lot of parties involved will send out a request for discovery, and they'll ask for the periodic statements from the credit card accounts, but they'll overlook the one key piece of information, and that's the application for the credit card itself. As you know, if you've ever applied for a credit card or a car loan, primarily those are driven by what you put down in the way of income for yourself. So those pieces of information will be included on there, and if you ask for credit card documents, make sure that you ask for the application for credit when the account was originated, because that will help you as well in proving income. You want to also obtain things like tax returns, and like I said before, if there are large purchases, things that you know a party has purchased during the past year, what you want to do is look at those items, whether it's a big screen TV or a fishing boat or a trailer or a ATV, anything that's a large item. Get a copy of the receipt for that item. Typically those are things that are kept by the vendor, or you can get them from your spouse if they kept the receipt, and see if that's a cash purchase, because those things can add up quickly. If there's a cash purchase for $2,000, $5,000, $7,000, that factors into income as well. And in cases where you're having some difficulty proving what a party makes in the way of income, that can put you over the top as far as proving what they've spent during a given year and showing that, in fact, they have cash coming in that they're not reporting on their tax returns. They have cash coming in that's not making its way into a bank account. And it's your job to prove, and it's your burden to prove to a judge that they're fudging the numbers on their financial affidavit, or they're providing testimony to the court that's not truthful. And I can tell you from experience, when you go into a court and you have your ducks in a row and you have this proof available, and you're able to show that the other party has lied a few times on financial matters, judges are more likely to believe you at that point than the other party. And if you can get 2 or 3 or 4 good hits in with documents to back up what you're saying, to show that the other side is not being honest, oftentimes you can get the judge going your way from a credibility standpoint and able to demonstrate that the other party is lying about a few things. So what we're going to do is we're going to take a break for a minute. I'll be right back after the break.
Attorney Sean Shepard has been practicing family law for 18 years, and he is in good standing with the Florida Bar Association. Attorney Shepard is licensed to Florida, New York, and New Jersey. He is a trial attorney with his primary practice in the area of family law litigation. He has handled thousands of cases and hundreds of contested trials before both judge and jury. Attorney Shepard is a former judge, advocate, general court officer from the United States Navy, and therefore possesses a wealth of knowledge regarding military-specific issues to divorce and other family matters. Attorney Shepard not only handles matters from intake through trial, but he also handles all matters of post-trial and appellate work. His unique background has enabled him to develop a keen insight into all aspects of family law litigation, from beginning to end. If you or a family member are about to go through a divorce or have other pending family law problems, contact attorney Sean Shepard today at 954-632-0668. Let attorney Shepard give you sound advice and fight for your rights. Offices in Fort Lauderdale. Call him today to make an appointment. 954-632-0668. You are listening to the South Florida Family Law Show with attorney Sean Shepard, bringing you all the answers to the questions you have about family law. Join the conversation at 888-565-1470. Now, back to our show.
During the break, we had a question that came in, and it's a question that arises a lot in situations where there's an alimony or child support obligation, and the question is, are there consequences, and what are they for a party that doesn't pay alimony? And this answer applies not only to alimony but to child support as well, and certainly there are consequences for non-payment of alimony and child support. Whenever you have a situation where you're entitled to receive child support or alimony and the other party's not paying in a timely manner, or they have an arrearage amount that's not being paid, you have a right to file what's called a motion for contempt and enforcement. And unlike other aspects of civil litigation and family law, when you have a support obligation, such as an obligation to pay for alimony or child support, and the other party's not complying with their obligations, you have the court has contempt powers over that party. And what contempt does is it brings a whole new level to enforcement. Typically, in cases that are civil in nature, enforcement comes in the form of a money judgment or other remedy where you have to go after somebody to try to collect money that's owed to you. When it comes to support, such as alimony or child support, the judge has contempt power, and contempt power allows the judge not only to impose upon the non-paying party obligations to pay for attorney's fees and costs of the other side and to do certain things, but it also allows the judge to actually incarcerate the other party if they fail to pay in a timely manner. So hypothetically speaking, if somebody is behind $5,000 on alimony or child support and there's a motion for contempt enforcement paid, if the judge feels that the other party, and there's actually findings of fact in the order that demonstrate that the other party has the actual ability to make the payment and has willfully and failed to comply with the court's order in the payment of alimony or child support, typically what the courts will do is the courts will impose a purge amount. A purge amount is basically if somebody's $5,000 behind in alimony or child support, the order may say this party's in contempt of this court, in willful contempt of the court's order, and not paying alimony or child support. There is an arrearage of $5,000 at this time, and a purge amount of $5,000 is due by Friday at 5 o'clock, failing which the non-paying party shall be incarcerated at the jail, until that amount is paid. What it does is it gives some leverage to a party that's relying upon that money in the way of support to force the other party to pay. And it's very effective for obvious reasons. So that's what happens if you don't pay your alimony or child support. In addition to having a contempt power, like I said, if you have a situation where you're not being paid your alimony or child support and you have to file a motion in order to force them to do that, and you have to hire an attorney and go to a hearing and do those things, the judge will typically also award you your attorney's fees and costs for having to do that. So if you're in a situation and you're concerned from a monetary standpoint that you can't afford to go to court to enforce your alimony or child support award, keep in mind that you are able to recoup your attorney's fees and costs, and there is that ability to have the other party locked up if they don't pay the alimony or the child support. So you do have some leverage with the court in that regard. That's a good question. With regard to the proof of income, we were talking before the break about getting all your ducks in a row and proving what the other party spends in order to prove what they're making. And we were talking about large cash purchases, things that they purchase. Take a look from a broader standpoint into what they've purchased. What do they like to do? I've had oftentimes situations where you have a spouse, and typically a male, who likes to fish, or he likes to buy tools, or there's something that they do that's a hobby of theirs, an expensive hobby that you can look at and assess how much they're spending on those things. I had a case, for instance, where there was a mechanic involved. It was a long-term marriage, and they had a huge tool collection, and I was able, during the course of the case, to obtain a ledger from the tool vendor that they purchased their tools from. I was able to get a third-party subpoena to the tool vendor, and they were able to tell me exactly, what tools were purchased, when they were purchased, how much they were purchased for. That type of information is very helpful in trying to prove what a person makes based upon what they spend. It's also helpful in proving that things such as that, which are substantial in value, tool collections in particular, are oftentimes things that are overlooked in an equitable distribution case, and something that you should focus on because there's a lot of value in those types of items, and they are certainly most of the time marital assets if they're purchased during the marriage. But if it's not tools, if it's fishing boats, fishing gear, fishing rods, whatever the case may be, if there's something out there that the party's passionate about. I have a case where I have a party who's passionate about guns. They have a huge gun collection, and was able to get discovery from the gun vendor as to what they spent on ammunition and weapons and things like that, which is very helpful in proving a case not only on what they spend on a regular basis on ammunition when they go to the range and shoot, but also on an equitable distribution standpoint, in proving that the guns were actual marital assets and they were subject to equitable distribution. So again, take a look at the case and then tell your lawyer, if you're not represented by a lawyer, tell the judge what the person is passionate about, what they spend their money on, and go after that information and allow it to help you in proving what the other party makes in the way of income. Another issue that comes up is gambling, for instance. If you have, again, trying to prove income of a party, a lot of people are involved in gambling and those types of things. If they go to casinos, if they go on the ships and gamble, you're able to obtain third-party subpoenas from these types of entities as well to prove what the party has spent. A lot of times people who gamble on a regular basis will have what are called casino cards, preferred cards, that track what they've spent in casinos, that track what they spent on gambling vessels, things like that. And you're able to obtain that information and prove to the court, again, how much they're spending is how much they're making. A lot of online gambling is happening as well. You can also attempt to prove what a person is making or spending based upon that as well. So all these things factor in. And if your spouse is engaging in those types of activities, it's something you want to bring to the attention of your attorney, and certainly something you can use in a particularly contentious case to prove what the other party is making from an income standpoint. I want to talk for a few moments about some issues related to income. And a lot of people, like I said, have a traditional situation where they're making an hourly wage or they're making a salary, and they get the same amount of money typically every pay period. And a lot of things that are overlooked in the calculation of child support specifically, and also in alimony cases, are what are called in-kind payments. And in-kind payments or reimbursements are things that are paid to somebody that have value to them, that they otherwise would have to pay personally, but somebody reimburses them. So for instance, if the employer reimburses a car payment or reimburses gas charges or toll charges, or provides a deferred compensation in the form of contributions to their IRA or their 401k account, these are things that you're allowed to utilize in trying to boost up what the other party's income is, because as you increase the other party's income, it increases the child support to which you're entitled, and it also increases the basis for your alimony claim if you're seeking alimony. So disclose to your attorney if your spouse works and they get their car payment reimbursed or gas or other things reimbursed. Make sure you tell your attorney about that, because those are things that can factor in and could actually increase your child support and your alimony award that you receive. From a military perspective, if you have a spouse that's in the military, military receive things like housing allowances, food allowances, they receive hazardous duty pay, things like that are beyond what their base salary is. There's a myth that circulated for a number of years that housing allowance and food allowance is not something that factors into the child support amount. That's nonsense. Everything that you receive in the way of income is typically included in the child support calculation here in the state of Florida. So if you have a military member, at the end of each month they get a statement that reflects what their base income is, their base pay, their housing allowance, their food allowance, their hazardous duty pay, anything else that they receive is indicated on that sheet. All of those things factor into the calculation of income for child support and alimony purposes. So make sure that you bring all those to the attention of your attorney. If you're not represented by an attorney, Don't get led down a path to believe that the only thing you can receive in the way of child support is an award based upon the base pay, and that all these other allowances are not included in the calculation. Again, that's nonsense. Everything is included in the calculation. So keep that in mind. If there is a situation where, and I just had this situation come up in the last 2 weeks, where you have a paternity action or even a divorce action, and the spouse or other parent has other children with other people. Child support is driven by a calculation of income and other factors, things such as daycare expense or health insurance expense for each party. Those things all factor in, and the information is put into a computer system and it spits out a child support number. One other thing that's also a consideration and a factor in determining what your child support is whether that party's already paying a child support obligation for another child to another party. So if you have a situation where, and again, this situation comes up a lot, unfortunately, you have a situation where you have a child with this person, and your child may be 2, 3, 4, 5 years old, and they're now in a relationship with somebody else and they're having another child. Go ahead and get your child support award put in place, because if you wait on that and something happens to the relationship that party's having with another, and there's a child support award imposed against them by another party, you're going to be at the back of the line as far as what you're going to get in the way of child support, because your child support demand is going to be affected by whether or not they're paying child support to another party. So rule of thumb there is first to the courthouse has a better idea of, or a better chance of getting a higher award of child support than the second to the courthouse. So act promptly to go ahead and get your child support awards in place, and don't rely upon some informal agreement you may have with the other party that they're going to continue to pay you X amount of dollars for child support. And that happens a lot. You have situations where parties are in no rush to get a divorce. They may have been married and separated for 2, 3, 4 years and stay married to one another even though they're in relationships with other people. And everything is going along fine and everybody's getting along, and there may be support exchanged between the parties. I don't advise you to do that too long, certainly on a temporary basis to keep money flowing from one side to the other. It's important to have that good relationship with the other party. But at some point in time, you need to get some structure to the relationship, particularly when the other party gets involved in another relationship with another person. You want to have some order of paternity in place that establishes what child support's going to be, establishes what a time-sharing schedule is going to be, just in case things go poorly, the relationship sours, and you're stuck without any type of agreement in place. You want to make sure that you get to court and get an agreement in place, and all the more reason, if you're getting along with the other party, to go ahead and have an agreement drafted up while you're getting along as to what's going on, what the child support amount's going to be, and what the time sharing is going to be before things go south. With regard to all of these issues, the primary key here is to have all your ducks in a row and to prove what the income of the other party is for calculation of child support and alimony purposes. And there's several different ways to accomplish all of this. There's no way that's better than others. I would say to attack from every different angle you can attack to come up with as close to an accurate figure for income of the other party as possible. So look at not only their financial affidavit, look at the documents that you obtain from them in the form of bank records. Look at a year's worth of bank statements, for instance, see what the total deposits were, see what the total expenses were. Look at a cash flow analysis from that basis. It's not complicated. It sounds like it's a real burdensome task, but going through 12 months of bank statements and writing down 12 numbers, which is the total deposits for each month, and writing down the total subtractions from the account for each month doesn't take a lot of time. You can get that done in an hour. And oftentimes that's very fruitful to look at it from that standpoint. because you do show a cash flow coming through. The times you're going to have difficulty is if you have a deceitful spouse or somebody who's trying to hide something from you. And oftentimes when an alimony claim is made, it makes a bad situation worse, and you're not going to get much cooperation from the other side. And when you have businesses that have cash payments, and even businesses that don't have cash payments, you may have a business that has all checks that come in that unfortunately you have a situation where somebody has a small business, a painting company or any type of service-based industry, and they go out and do a job, and they get a check for $5,000, and it's made out to them personally, and they go to the bank and they cash the check. There's no way to really track that money if you have a deceitful spouse involved, or somebody's not going to be forthright with you and tell you that they made that money. And you have to be able to track down that money. Where did it come from? And the way that you do that is, particularly in the construction industry, by way of example, is you look at who they provided services to over the course of a year. Look at all the receipts they have for things that came in during the year. Look at all the project addresses where they did work for the year. Find out in a deposition, who did you do work for this year? When did you do work for these people during the year? And if you find a gap in time where there's no income coming in and no other project they were working on, they were probably working on a project where they got a check and they cashed it and they pocketed the money, and they're not going to put it in the bank anywhere. It's not going to show up on their income. It's up to you to track that down. And there are ways to do that. You have to be diligent about doing it. You have to be motivated to do it, which most cases you are. But there's ways of finding all that information out. With construction businesses, subcontractors, general contractors, you can oftentimes do searches through the public record. These are just ideas. Searches in the public record to find out if there are notices of commencement for work that they did, to find out if there were that they filed liens on projects. And that's all free to do. You can go online, go to the official records for Broward County or Palm Beach County or Miami-Dade County, and put in. You can go on the official records. It's free to search it. You go on there and you type in a date range from the first of the year to the last of the year, and you type in the name of your spouse or the name of your spouse's company, and it'll print out for you a list of all instances where they've recorded anything in the public record from construction perspective, notices of commencement of work, those types of things. And what that does for you, particularly in a case where there's a construction business or a subcontractor involved that's your spouse, it allows you to get a lead to ask questions about income. So if you're able to get 4 or 5 notices of commencement, and you're able to show up at a deposition and confront your spouse about projects, and say, okay, here's the notice of commencement from October of last year. It's the address for the project will be on there. You're able to then ask them about the project. How big was the project? How much did you get paid for the project? And a few times I've been able to uncover situations where there was no income for a couple months, and it turns out that the subcontractor was working on a project, that they received a check that was made out to them or to cash. They cashed the check and didn't deposit it in the bank. So that type of investigation, again, that type of search that I just explained to you how to do, it takes 30 minutes of your time to do that type of search if you have a spouse who's involved in a construction business or a subcontractor business. And that 30 minutes could uncover tens of thousands of dollars in income that you otherwise wouldn't have found. So there's also the ability to go on to sunbiz.org, sunbiz.org, again, a free site, and that'll allow you to search for companies that your spouse may be a member if it's an LLC, an officer or director if it's a corporation. You can see if they set up companies. If they're part of companies, if they have any fictitious names they're doing business as. Sometimes you have a spouse who has an entire business they haven't disclosed to you. So do that type of research. All this is free. All of it's available online. So it just takes some time to get your ducks in a row and be prepared. It's a daunting task. It's not fun to do. But if you devote the time to it and you really go after trying to prove that your spouse actually makes income that you think they're making, you could be successful in going to court and proving that. So spend the time to do it, find an attorney who's willing to do it. And if your gut's telling you that your spouse is making more money than they're claiming, you're probably right. But you do have to prove that. You can't just walk into court and expect the judge to believe what your opinion is. You have to actually provide proof to the court that that's happening. With regard to family law cases, the financial affidavit also is something that can help you in these instances. As I explained, typically in the first 2 months of your case being filed, both parties have to file their financial affidavits. And if you can catch your spouse not being truthful on the original financial affidavit that was filed by going through and doing the homework as I've explained you to do, and going through the effort, going through the due diligence and proving that they're actually making income that they haven't reported, that is something you can bring to the attention of the court if you go to a contested trial. You're allowed to attack the credibility of the other side. And like I said, if you attack the credibility of the other side and you're successful, the court does not like dishonesty. And you have judge-alone cases in family law court. There's no juries in any family law court action. And if you're able to get the judge on your side and prove that the other side is not being honest, a few of those, as you're able to snowball that and able to show that the other part is not being honest in a case, the more likely you are to get the relief you're seeking, and the less credible the other side's going to be in the eyes of the court. So spend the time doing that. If you have an attorney and you're trying to save money, a lot of people have attorneys and don't want to spend money on this type of research. Do all the research yourself. Bring it to your attorney's attention. Do some of the legwork yourself and try to save some money in that regard. But it's definitely worthwhile, because in any increase in income that you're able to establish for the court, you're able to increase the amount of child support that you're going to get. You're able to increase the amount of alimony you're going to get. My name is Sean Shepard. I'm here from 5 to 6 o'clock every Friday. I'll be back next week. I'm available. My number is 954-632-0668. I'm available for free consultations. If you're a new client, have a new matter, I can confer with you on the telephone, and we could set up a free consultation in my office. My office is located at 500 East Broward Boulevard, Suite 1600, downtown Fort Lauderdale, on the corner of Broward Boulevard and Federal Highway. I practice in Broward County, Palm Beach County, and Miami-Dade County. If I can be of assistance to you, please give me a call, 954-632-0668. Thank you, and I'll talk to you next week.
Thanks for tuning in today to the South Florida Family Law Show with attorney Sean Shepard, with offices in Fort Lauderdale. If you would like to set up an appointment with attorney Sean Shepard, call his offices at 954-632-0668. And tune in again next week for another South Florida Family Law Show with attorney Sean Shepard. And let Sean answer your family law questions. The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors.